Mr. Spy.
Thank you, Your Honor. Good morning. May it please the Court. My name is Howard Speicher of Davis, Malm, and DeAugustine. I represent AL Prime Energy Consultants, the owner of a gas station in Groton, who obtained a special permit to replace older one-hulled gasoline storage tanks at its gas station in Groton with two newer double-hulled state-of-the-art gasoline tanks, and to make certain other improvements to the gas station. Back in 2003, we obtained a summary judgment on the issue of standing at the Superior Court level.
Well, actually, it was a 12B1 motion.
It was a 12B1 motion. You're right, Your Honor. I sometimes
Can I just interrupt you for 1 second?
Yes.
Do you have any papers? I saw it in an amicus brief, but do you argue anywhere about the appeals court decision? Or
We filed a motion for further appellate review, Your Honor. I mean,
I know that, but I mean, but your brief.
We didn't file an additional brief.
Okay, so it's
our
your
argument-
argument is in the further appellate review.
Yes, Your Honor.
Thank you.
And that argument is basically on, without getting back into the facts, if we just want to move ahead, what happened in the appeals court is that the appeals court, we believe, effectively overruled a long line of cases about how standing is established, rebutted, and then reestablished in zoning cases. The way it's worked since going back to Watros and Murata and on through Marashlian and most recently Standerwick, this court's opinion of a couple of years ago, is that an abutter or an abutter to an abutter who is entitled to notice of a hearing before a board of appeal or a planning board on a zoning matter has a rebuttable presumption of standing.
Mr. Speicher, may I just ask you something? I have not listened to the oral argument in the appeals court, but this argument that the bylaw confers standing, which is the basis of the appeals court's decision, was not argued in the briefs at any rate. Was this?
No, it wasn't, Your Honor. It
So
didn't
it
come
just
up until we
came-
read the decision.
So,
Well, you say that, but I noticed that there is this footnote in the appeals court case that suggests it was raised.
Well, no, there was what came up in the appeals court is just a question of which was the appropriate board to be before. There was one of the judges noted that a version of the bylaw that they'd looked at said that the zoning board, as opposed to the planning board, which issued the special permit here, may have been the appropriate board to go before, but they said we're not really looking at that. What turns out to have happened, Your Honor, there are two versions of the bylaw in the record appendix. By accident, one of them contains an older version in which the zoning board was the previously the special permit granting authority.
I'm quoting the appeals court in footnote 6, which is quoting the abutter's brief in the appeals court, which says the abutter's concerns about the potential threat to their drinking water is exactly the type of concern that the zoning bylaws were intended to protect. The abutters have made their fears known through the affidavit testimony. They need not offer expert testimony or scientific evidence to show the potential for harm to their legal rights. The abutters, therefore, have put forth credible evidence. Sounds to me that that's sort of the argument that was ultimately...
I'm sorry, Your Honor. I might have misunderstood. The abutters argued that they either didn't need to provide any evidence or that what they had provided was credible evidence. And I might note that they refer to their affidavit testimony in the Superior Court. There was none. The record contains no affidavits. There were no affidavits submitted. The only evidence offered before the Superior Court, in fact, Your Honor, was the oral representations of counsel, which have been reproduced in the first volume of the record appendix in the form of a transcript of the Superior Court hearing. There was no affidavit or other support offered at the Superior Court for those representations. But even if those representations, Your Honor, had been in the form of a proper affidavit, they amount to nothing more than what this court and the appeals court has said over and over again is mere speculation or hypothesis or subjective fears that do not qualify as credible evidence sufficient to bring back the presumption of standing that gets negated when the landowner puts forth credible evidence to rebut the rebuttable presumption of standing. Now, the landowner in this case in the Superior Court presented and this is all in Volume 2 of the Record Appendix, presented affidavits of civil engineers, lighting engineers, and others. A traffic study was presented, and stamped engineered plans were presented to rebut any presumption of standing on all of the issues raised by the plaintiffs in the Superior Court with respect to issues like traffic, lighting, noise, trespass that they claimed would occur on their properties, things like that. The Superior Court judge and the Appeals Court found on each of those issues, with one exception that I'm going to get to, that the landowner presented the evidence that was required to rebut the presumption of standing, and that in all of those cases, the plaintiff abutters failed to present any credible evidence of any harm that's protected by the bylaw. Then what happened at the Appeals Court level is the Appeals Court said, with respect to the issue of groundwater, the court agreed that, as in the other cases...
Experts were correct.
Excuse me?
The Appeals Court agreed that your experts were correct.
We were correct, and that the plaintiffs did not present any credible evidence on that issue either, on the issue of their fear of groundwater contamination. But the court went on to say, and this is the key sentence in the decision, said, however, the bylaw codifies the abutters' fears. And that statement, and which became the holding of the case, that their mere fears could establish their standing, was justified not as new law, but the court relied on Monks versus Planning Board of, or Zoning Board of Plymouth to support that proposition. And our contention is that's a misapplication of the Monks case. The Monks case was a case in which the abutters who protested the issuance of a special permit for a cellular telephone tower protested on the basis of its impairment of the visual character of the town as it affected them.
It's really a misapplication in two ways, right? I mean, number one, it's a different kind of thing. That is, I think an affidavit could say, a person, just a lay person, could say, you know, this is where my house is, this is where the tower is, it's going to disturb my visual...
Which is what they said in Monks.
Right? Which would be evidence. So one difference is just the nature of the interest involved, and the other is evidence versus none, right? I mean,
yes, because there was no evidence whatsoever here. In the first instance, as you said, Your Honor, in Monks, as the court found in the appeals court, in this case, in Monks, impairment of visual character, the court said, would not ordinarily be something that is protected by a zoning bylaw unless the bylaw specifically said so. And
but wasn't the tower in Monks didn't it exceed the height requirements of structures that were permitted under the zoning code?
yeah, but there was a special section of the bylaw for cell towers. It was a separate special permit.
And what Monks held was, notwithstanding that, the bylaw gave persons who...
Conferred potential standing.
Potential standing.
Yeah.
Right.
And in fact, in Monks, the court never said, well, if it's in the bylaw, what the court said in Monks is, well, if it's in the bylaw, well, now visual impairment is potentially an issue that somebody can raise. Ordinarily, it might not be. But in Monks, there was evidence. There was evidence that the found court to be competent, credible evidence of an impairment of that visual character. The plaintiffs in Monks said, we look out at this ordinarily pristine environment and we see this cell tower from every window in our house. The court found that that was enough. In this case, the court found that, well, groundwater protection, because of the language in the bylaw, which specifically talks about the special permit granting authority, considering the issue of groundwater contamination, the court found, well, that's something that can confer standing. But the court took this next step and found that they don't need to have any evidence to do it. And that was the fault in the appeals court decision, because the court specifically found that the plaintiffs did not submit credible evidence. There's no need to go back to any Superior Court hearing with this matter, because the Superior Court and the appeals court agreed that there was no credible evidence of any impairment of groundwater. But the key fact here, the key holding was that they don't need to. And that's just not the law. It's not the law as this court reiterated in Standerwick. It's not the law as this court found in Marashlian, or as the appeals court found more recently in Butler and in numerous other cases. The decision of the appeals court, if left to stand, we believe effectively overrules Marashlian and Standerwick on the law of standing and really changes the law of standing as it's been put forth by this court and the appeals court over the last 30 years.
Thank you, Mr. Spicer.
Thank you, Your Honor.
Mr. Donahue?
Good morning. May it please the court. My name is Matthew Donahue. I represent the abutters of Greg Sweenie, Pat Kenny, and Jack Kane. I'm here with Joe Jassam from our office. To overturn the appeals court's decision will effectively close the door to any abutters' access to the courts.
Why is that?
Why?
You are going to require, and what the law requires currently, in any, Judge Botsford, you touched on it, in the nature of the circumstances covered by zoning. What the court is requiring, if it's overruled, is that the abutters, residential abutters to a commercial use, would be required to do groundwater studies.
So?
Cost prohibitive. They'll never come here.
But isn't
They'll
that
never
the
be in court.
Before this case, I mean, it seems to me that under law of zoning law, an interest in protection of groundwater has been a protectable interest, regardless of the Groton bylaw. I mean, that's just one of the recognized interests. But and assuming that to be the case, it has been so that to acquire standing, one would have to put on some credible evidence, which is more than just saying, I'm afraid.
No, the concern is that the unique circumstances of this case, the facts, are all in the record, is the topography of the area. To understand this case, which any judge would do after a trial when they went on a view, they would have all the evidence they would need to make a decision.
But there was expert evidence put in by the town, and, put in by the planning board, and that was credited by the Superior Court and credited by the Appeals Court.
The expert testimony, of course. Right. That's the proposal. The proposal is to build and expand a gas station into Mr. Kenny's backyard.
So what was the evidence that plausibly demonstrated a cognizable injury?
If you look at the proximity of
No, we're not scientists.
You don't have to be, Your Honor. That's the point.
Because I've got an old gas tank that may well be leaking at the moment, and I'm going to replace it with a new, much more secure gas tank.
But that's always the developer's promise, Your Honor, before any board. They're going to improve everything.
But wasn't
That's
there
not the
evidence
case
that they-
here. If I can just get back to the point.
Yeah.
If we have Mr. Sweeney's backyard, okay, horseshoe like this,
Yes.
hill up to a gas station, okay, we could say that it's general knowledge that he has fundamental awareness. These things are so ubiquitous in terms of a canopy use, the expansion of a use in a commercial zone, expansion of a non-conforming use. He's adding a grocery store. He's adding a canopy. He's adding a dumpster. He's directing traffic around the back of the property, just running along the Sweeney property.
All of those were taken into account by the planning board.
Correct. But to have standing to challenge
You
that
have
premise,
you have to come forward with some. The law is very clear. You have to come forward with some credible evidence.
what's the problem with a citizen witness saying that he objects that the planning board, understand in a 40A appeal, it's the claim ultimately we have to prove is an exceeding their authority. The planning board has exceeded their authority. They cannot expand a gas station in a water protection district. Cannot happen. Not allowed. Where can a citizen go to stand and make that claim as a private attorney general?
So would we have an exception to our general rule that says there must be credible evidence, except in those cases involving issues of water, or in those cases that are extremely expensive to produce the credible evidence?
No, Your Honor, you're going to be...
How are we going to do it?
You're on a slippery slope here, Your Honor, because any air quality issues, nuisance, noise, lighting, measuring lumens, traffic experts...
Too expensive.
All of those things require enormous amounts of resources, number one.
But
To get standing, Your Honor. Just to go into court.
Mr. Donahue, it's not just to go into court. You can make any claim, but the law is pretty clear that you have to have some credible basis. You have to have some credible basis in order to, in other words, you might say, oh, it's just my worst fears. I don't like the humming sound.
Your Honor, the decision, the ultimate language in the local ordinance assumes failure. That is, if the water protection district there is a high degree of consensus in the community that protecting drinking water is very important. So the language that the appeals court relies on, the degree of threat to water quality that would result if the control measures failed. Now, we're assuming when the developer makes their traditional promise that they're always going to do it right, that there will be no leaking, that it will be done properly. And that's the bias that you have here. First of all, the court presumes that they're going to do this right. The bylaw says, no, you have to presume failure, that there could be a flaw that could contaminate
by your reading,
water.
you could never do anything in terms of water quality in this district, right?
The water protection district does not allow for gas stations, Your Honor. There are no new gas stations allowed pursuant to local zoning. This is the expansion of a gas station. They're adding more tanks. You have to put expansion. This isn't an upgrade. They're not doing anybody a favor. They're expanding gas stations, adding more stalls, adding a grocery store, adding a canopy. This is an expansion that pushes back into Mr. Sweeney's backyard, up the hill.
What happens if there's a trial and they present evidence, I assume they already have presented this information, that these tanks are not going to fail? What do you do then?
Well, Your Honor, this is the question I have, is what if it's a legal issue of authority? That the planning board, in fact, does not have authority to expand a gas station in a water protection district. Now what you've done is you've put the gauntlet in front of the only person who can make that claim and said, you've got to get scientific data. Your evidence is not credible. Mr. Sweeney cannot be believed.
Is there something in the bylaw that says they cannot expand a gas station?
The water protection district does not allow for new gas stations.
This is
Not a new gas station.
It's the expansion.
Is there anything that
it's
says
adding.
that you can't expand it?
Well, that would be our argument, Your Honor. And that should be a legal argument that a citizen should be able to go to a court and make. The planning board, of course, wants to expand their tax base. They want the grocery store. The developer of this project wants traffic to come to this site.
I understand that, but we do have at least some standing requirement here, and we've articulated it over and over again. It requires some credible evidence of a plausible injury. I'm looking at the depositions. What's the basis for your belief that this will cause damage? The first would be we're in the middle of a water protection district, and all the homes use well water, and that any increase in the storage of gasoline could potentially contaminate the water. That's it.
General knowledge,
Something bad might happen.
General knowledge. Contamination is going to, if they fail, the leak goes into the groundwater, impacts their drinking supply.
The argument you're making wasn't even addressed by the appeals court, that they had no authority to allow the expansion of a gas station in a water protection district. They didn't even address that. They just said this bylaw appears to give them standing in terms of dealing with the issue of whether these tanks fail or not.
Correct.
Right?
That's correct.
Well, that's entirely different than what you just argued.
No, but where does someone go? In other words, if what you...
Maybe nowhere. Maybe you don't have any rights.
That may be the point, and that's my opening statement. My opening
Did you raise
statement
that
was...
argument in the Superior Court?
What's that argument?
That the planning board does not have the authority to expand or to permit the expansion of a gas station.
Well, if you go to their very last footnote in their... This is the predicament that we're in. That I'm in,
But my
and that
question
we're all
is,
in.
did you make that argument in the Superior Court?
No. And the reason is because the debate as to whether this case now has to go to the Zoning Board of Appeals. There is a dispute at the local level between town council and the building inspector as to whether or not the other aspects and uses of this property now require a zoning board special permit. We are victims of a segmented regulatory scheme, one that says the planning board, and only the planning board, shall issue tank permits. That's all they do. So once you've got the tanks in the ground, it's kind of like having the foundation for the house. Now try to grab the momentum to have an articulate and reasonable discussion on whether or not the expansion of the non-conforming use is allowed.
But
The
isn't
citizen
that, I
then-
mean, that seems to me to be a problem with the bylaws of Groton. I mean, I don't see it as
It
some
is.
constitutional issue or some.
No, I'm not saying, well, no, I'm
But
not sure.
I mean, it becomes, in that sense, a political issue, doesn't it?
Correct. And that's the ultimate.
But
that's
now you can
point
make
here.
the
What-
argument you've just made before the zoning board of appeals, can't you?
We can. We may have a round 3. And to put this in a context, round 1 was the defeat of the developer's desire to rezone a vacant piece of land next to him, which is currently residential, to business. That failed. This is round 2. He goes and he puts his permit in for his expansion of his tanks, which is just with the planning board, and which would then give him his tanks. And then part 3 would be, which is in dispute, whether or not the building inspector believes he should get a special permit for the further expansion of the non-conforming use by adding a grocery store. There are no stores. As this sits today,
So
it's
the question of the expansion of a non-conforming use, and whether a variance is required or some special permit is required, that's for another day.
that could be for another
But
day.
that doesn't go to the tanks.
No, it doesn't.
Does not go to the tanks.
Correct.
But we would still argue that Mr. Sweeney's a credible witness,
So
and that what he has presented is enough under the facts and circumstances of the case. Otherwise, you're requiring to hire a groundwater expert. There are Superfund sites in this country that have been active for 25 years that no one knows where the groundwater is going. That's what you'd be asking. That is the standard you'd be asking. For any resident abutter abutting a commercial property that sees the beginnings of an expansion.
That is the standard.
I'm sorry?
That is the standard, because I think Justice Cordy just read his deposition testimony. What's the basis for that?
I think maybe this is Alice in Wonderland for me, Your Honor. It could very well be. I don't understand why Mr. Sweeney can't say what he said in his deposition and that be adequate.
Because we have held that for somebody to say, I just know it's going to increase the traffic, that that's not sufficient.
But this is different, Your Honor. We can't say that here. We'd have to have a traffic expert to somehow measure that. We're talking about groundwater contamination, a very complicated, sophisticated harm that a community put a high stake on and instituted legislation to say, look if these guys mess up, we don't have drinking water. So, yes, a new standard has to be looked at for a residential
We're not
abutter.
talking about if these people mess up.
The
Nobody's getting the benefit to anything. Presumably, the local authority looks at what is proposed.
Presumably, Your Honor, yes, but then we're in politics again. But what about an abutter? Where does he go to say they're not doing it right?
Well, when
The
they
presumption-
when they don't do it right, he can bring an action to say this is in
It's-
violation of the basis of the permit.
But in these circumstances, Your Honor, there's contamination.
So you
It's
say a
cont-
person
there
ought to
isn't-
be
There's
able,
no evidence of contamination.
Your Honor, the control measure in the bylaw presumes failure. You have to. The stakes are that high. If you start and allow someone to start a job and they do it improperly, this isn't like a botched traffic study. This is a release for which, yes, he could call DEP, and they could call the EPA, and they could have all sorts of mitigation measures, but he lives right next door. 55 feet from the edge of his pool is going to be, this gas station, where now there are woods. Okay, now he can't raise those issues, but once the tanks are there, the implication is the groundwater floods down this bank to his property. It runs across Mr. Kenny's property, which is next door.
There's
So
no
the
evidence.
implication can be general knowledge, Your Honor. In Marashland, he can go and say, I am generally aware that I sit here every day and I'm in my backyard. The difference, Your Honor, is these cases, Monk is the exception. These cases, Butler is traffic on Trapello Road. Okay? All very quantifiable, subject to algebraic calculations, air quality, these types of issues. But what about the quality of life of a citizen in their backyard when Mr. Sweenie is having a birthday party for his triplets?
What's he going to do with the trial of the case itself? I mean,
Well,
is he going to rely on the same thing?
No, we'd have to provide testimony then to prove our case that they've exceeded their authority, that they have not properly evaluated the situation, and that we would have an expert who would testify saying this is what the possibility that it could occur. And that's exactly what our point is, that they've collapsed the trial standard onto the jurisdictional question and have said, well, because you cannot prove standing and you cannot get in the courthouse, the credibility assessment is done up front, and we don't believe you, which is a trial court determination, and no cross-examination ever occurs. It's all done on affidavits. It's done, and you've closed the door to the court, to the resident who needs the court most.
Well, one
The
way or
judge
the
does
other.
make it, excuse me.
No, go ahead. One way or the other, you're going to have to get the expert.
Correct.
And the standing requirement says you have to get it early, because if you can't get it, we have to save ourselves the expense of a trial and save the other party the expense of a trial. You're going to have to get the expert at some point.
For a trial.
And we
For a
say,
trial.
no, we say, you're going to have to get the expert. Get him now, and we'll decide. And if you do have that kind of evidence, then we'll have the trial. If you don't have it, then we're not going to go through the expense of a trial.
To get into the courtroom, you have to have your entire trial prepared.
That's right.
Right. That is unfair.
Why?
Because, first of all, have your client fork over money for thousands of
They're
dollars
going
of
to have to
experts.
do it anyway.
Correct. If they get into the courtroom,
But
if
on
there's
your theory-
cross-examination, if there's a trial, you can't come to court unless you can afford thousands of dollars for an expert.
That's the law.
That's the law, exactly. That's what I'm
Well,
telling
it doesn't
you.
have to be an expert. There are some circumstances, such as in the Monk case, where someone can say, looking out my house, the cell tower is right there. The bylaw protects the visual portion of this particular area of the town.
And that is an exception because a view is a view.
No, it's evidence. Yeah, it's evidence. Evidence. I can see it right there.
That's
I
right.
can see the tower. It is blocking my view. That is evidence of injury. Not I can see the gas station. I'm afraid one day I might get gas in my yard. That's not evidence of injury. That's evidence of concern.
No, it is not. It is an evidence. It is. I don't mean to argue.
No,
My concern, this is the issue, is when a non-expert citizen says concern, it's a fear, it is not credible.
No, it's
If
not,
an
it's not a
expert-
matter of being credible.
Well, that's what we have to put.
It's a matter of whether it's evidence.
We have to put credible.
Credible
I think.
evidence.
I think
Of
what the
injury.
court. I'm saying that the court is looking for corroborative evidence.
Well,
In other words, what you're asking for is, and we have the burden of not only production and persuasion. Once the presumption's gone, then our interpretation is that now the abutter merely needs to say, I need to produce evidence. I don't have to persuade you. That's what the trial is for.
but
I
just-
think you've collapsed the two on each other so that there is never an opportunity for the witness, the party, to press his or her claim
Mr.
in
Donahue, I'm
persuasion.
not sure that we will be able to persuade you.
No, you won't. You won't, Your Honor, but I'm only,
Time's up.
you know, I'm
Your
not going
time
to have
is-
many opportunities to be here.
Thank
But I think this is an important issue
It is an important issue, of course.
and I do believe, going back to my final statement, is that the court should hearken to this lowly attorney's words. There are other cases coming along in the appeals session that will deal with these environmental issues, and the ultimate result is that you are closing the door for citizens to get to court.
Thank you, Mr. Donahue.
All rise.